Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. President Trump is making headlines today with a recent interview he gave to the news organization Axios, in which he stated he's working on an executive order to end birthright citizenship in America. Such an executive order will likely set off an explosive fight in the courts over whether the president has the constitutional authority to end birthright citizenship. It's a big deal. Currently, according to the Congressional Budget Office, there are more anchor babies born in the United States every year than babies born to U.S. citizens. Anchor baby is a term used to define a child born in the U.S. to an illegal alien mother. Under the current U.S. government interpretation of the law, that child, a child born in the U.S. To an illegal alien mother, is considered a U.S. citizen at birth, regardless of the illegal status of the child's mother. But what is the source of this current interpretation of the law? It goes back to the 14th Amendment, which states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And the key phrase there is subject to the jurisdiction thereof. Now, supporters of the president's position argue the 14th Amendment was not designed to provide U.S. citizenship to the children of illegal alien mothers. Instead, it was ratified to give newly freed African slaves the constitutional right of U.S. citizenship upon their birth in the U.S. It had nothing to do and did not intend to confer automatic U.S. citizenship to children born in the U.S. whose parents were foreigners. The 14th Amendment, remember, came about in response to the Supreme Court's 1857 decision, Dred Scott, in which it held blacks were not U.S. citizens. So the 14th Amendment overcame and nullified the Dred Scott decision. That's what it was all about. Supporters of the president's position also argue the framers of the 14th Amendment itself meant what Trump has concluded. Senator Lyman Trumbull of Illinois, principal drafter, defined that clause, subject to the jurisdiction, as this, quote, not owing allegiance to anybody else, end quote. That is, no other country or tribe. Senator Jacob Howard of Michigan, a sponsor of the amendment, further clarified that clause to explicitly exclude from citizenship, quote, persons born in the United States who are foreigners, aliens, or who belong to the families of ambassadors or foreign ministers, end quote. Now, in further support of the president's position, the Civil Rights Act of 1866 defines U.S. citizens as, quote, all persons born in the U.S. and not subject to any foreign power, excluding Indians, end quote. Illegal aliens are subject to a foreign power, the country in which they are citizens. Now, opponents of the president's decision argue the Supreme Court has already settled this issue back in 1898. They cite the case United States v. Wong Kim Ark, in which the court ruled that children of legal residents who are born in the U.S. are U.S. citizens. Advocates of birthright citizenship now, they want to extend that ruling to also cover children born in the U.S. to illegal aliens. But that's a bridge too far. That's not what the case was about. The case was about legal residents and their children. Further, that same case tends to prove Trump's point. Legal residents are here legally and subject to the jurisdiction of the U.S. Illegal aliens are not here legally, and they're not subject to the jurisdiction of the U.S. They still owe their allegiance to the home country in which they are citizens. Now, some argue the best way to resolve this dispute is for Congress to take action. They argue Section 5 of the 14th Amendment confers upon the Congress the power to define the jurisdiction of the United States. It states, quote, the Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. the citizenship provisions. Also, Article 1, Section 8 of the Constitution grants plenary power, that means full power, to Congress to establish the uniform rule of naturalization, and thus, by implication, the power to write the laws on citizenship. That is, to whom citizenship will be offered and to whom it will not be offered. In any event, the president has set off quite a firestorm in the media, with most of the media attacking him for this proposed executive order and denouncing it as unconstitutional. Now, we'll see how this issue develops. We'll keep you posted along the way. That's about all the time we have today for the Scaringi Law Lunch Break. Thanks for listening, and enjoy your lunch.